officially live on YouTube. Um, and so if anybody has staff or anything that needs to, anybody that wants to watch it, just go to YouTube, Spalding State Court, and watch it. All right, so this is the court's non-jury calendar, non-jury civil calendar. This is March 8th, it's 9:05. There are two cases on this calendar. I'm going to do the calendar in reverse order. That is the second case, 23 SR 221, Cope versus Hardtech, has been moved to the end of March. No one is here for that. So I'm going to mark that on my calendar as reset, which leaves me with the last case on the calendar for today, which is 16 SV 89, Whitworth Maynard and Karen Maynard versus Crystal McGee and Snapchat. I just realized that it's no longer Snapchat, it's Snap. But our system still has it, and she's not McGee, she's Leatherwood, I think now. So if y'all can agree on an appropriate title and you want to send us a consent order, I'll amend it in here. I just realized I had 2 points that were not quite correct from the title. So that's just housekeeping for later.
We should be able to do that, Your Honor.
Okay. All right. So what I'm looking for from y'all is what's the plaintiff's list for today of things you're looking for from me, and then I'll get from the defense, and then we'll get started.
Thank you. Judge, we just have two motions. One is our motion regarding deposition conduct, and one is our motion to depose CEO Evan Speaker.
Okay, that's exactly what I have on my radar. So, Mr. Masterson, anything that you're looking for me specifically, other than just to address their two motions?
That's correct.
Okay, just want to make certain. And then obviously we do have the other outstanding matter of the question of the ownership of the cell phone. We agreed we would not delve into that today, other than to maybe just talk logistics of how, when, where, and to get that back in front of me. So, so I want Mr. Rutledge to go and be able to take that deep breath that I promised him he could take, that we would not be digging into that issue today, other than to talk logistics. All right. Okay. All right. Well, both motions that have brought us here today are from the plaintiff, and Mr. Adams and I have already tested the PowerPoint and it's up and going. Any housekeeping before we jump in?
Nothing.
Any housekeeping, Mr. Masterson?
No, Your Honor.
All right, Mr. Rutledge. All right, and I'll just ask one last time, just to make certain the record is super clear, since y'all all just met Kathy, if you'll just come across real quick and just state your names real clear, since I know you all, but Kathy Leach, our court reporter, does not.
Michael Neff for the plaintiffs.
Dwayne Adams.
Thomas Leach, Scott Masterson for Snap.
Brad Rutledge for Crystal McGee.
And Ruben Kahn for Snap.
And Mr. Khan is virtual. Okay, floor's yours.
Thank you, Judge.
Pleasure
Pleasure
to
to be
stand,
here in person.
sit,
Yeah.
wherever you want to be, so.
Thank you. Used to standing. I'll try that out for now. We appreciate your involvement in this case. I don't think I've ever had a judge who's given us this much of his time. And so I think one of the advantages of that is that the court kind of has a flavor for what's been going on. During our Friday conferences, I keep notes. I use the same notebook, and I'm going back to August 22 of last year, where we were talking about 30B6 topics. And the court said, I repeat, plaintiff picks the topics. And you were saying, and I have this in quotes, plaintiff is doing what I've asked them to do, but each thing I've laid out here, we're not on the same page, referring to Snap. We did get the deposition scheduled eventually in December. Mike and I traveled to LA, and we thought, look, after 7-8 years, this is our chance now to ask Snap about some of what we think are the indefensible choices it made. And you're about to get a flavor for what actually happened. At the outset, I would point out that our brief itemized 16 deposition topics, 30B6 topics, that we felt Snap inadequately testified on. 2, 7 through 11, 17, 20, 27 through 32, 36, and 39. Snap's brief responded to topic one, which we did not address in our motion, so we have no issue on that. But they responded to 2, 11, 20, 31, and 36. And to give the court just some more detail, I'll run through these quickly. 27 that SNAP does not address in their brief is other incidents in which Snapchat or its speed filter are alleged to have caused or contributed to the cause of vehicle incident. Other lawsuits alleging Snap or the speed filter, Snap's knowledge of other incidents, Snap's tracking knowledge in response to media and other commentary, communications to, by, or copying Snapchat with regard to the subject incident or its aftermath. And and one more, Snap's communications or interactions with Crystal McGee. In addition, Snap's brief does not address these topics that the second 30v6 witness, Ms. Morkayanis, testified to, and that's the history of the app. I won't read the whole thing. Identities of persons employed or contracted by Snap who raised concerns about the safety of the speed filter. Or otherwise known to Snap. Communications to, by, or copying Snapchat regarding safety implications, the history of disclaimers, origin, creation, and approval. And the topics Snap did address are just laid out here on the screen. In the interest of time, I won't read them all. The court should be authorized to conclude that Snap does not take issue with our points raised to the ones that it did not address. So the first of our concerns that we wanted to bring to you today, and it's not my intent to go through the whole brief. You have the briefs, and I'm sure that's not an efficient use of your time, but we want to talk about discussing and changing testimony during breaks. Under Rule 30C, and this is coming from Hall v. Clifton Precision. Now, you know, Judge, that I could, if I search all the federal courts in the country, I can find something I like. So this is a case that actually has been cited, I think at last check, about 190 times across the country, and including 2 in Georgia federal courts. So we think that this is more than just one opinion that supports us. So this says that depositions are conducted as if at trial, and it makes a very reasonable statement that during a civil trial, a witness or his lawyer are not permitted to confer at their pleasure during the witness's testimony. It says the same is true at a deposition. The fact that there is no judge in the room to prevent private conferences does not mean that such conferences should or may occur. And here's where I think it really gets into what happened in LA. It says the rules also apply during recesses. Private conferences are barred during the deposition, and the fortuitous occurrence of a coffee break, lunch break, or evening recess is no reason to change the rules. Because a clever lawyer or witness who finds that the deposition is going in an unanticipated or undesired direction could simply insist on a short recess to discuss the unanticipated yet desired answers, therefore circumventing the prohibition on private conferences. Many Georgia state and federal judges have formally adopted this rule, and we provided the court with a stack of standing orders. And they say
I
that,
reviewed all those.
pardon me, yes, sir. Counsel and their witness clients shall not engage, and the caps are in the original, engage in private, off-the-record conferences during depositions or during breaks regarding counsel's questions or witnesses' answers. And it says if they do, this should be noted in the record. So here's how the first deposition began, day 1. The witness, Mr. Cheek, walked into the room with a piece of paper among his documents, and they start out by handing out this piece of paper. And it listed 4 names: Niru Singh, Rachel Rakazan, Yining Ni, Brooklyn Poe. And much of the morning was spent exploring what did you talk to this witness about, and what did you say, and how long was it, and when was it? Well, so one of the things we wanted to understand is, why did Snap publicly comment that it removed the speed filter due to lack of interest? And the court will recall from the brief that an NPR did a story in June of 2021. And in that story, NPR said, what exactly led Snap to scrap the features now is unclear. We've asked Snap a few times, and a spokesperson said previously, nothing is more important than the safety of the Snapchat community. A month later, the same spokeswoman confirmed the speed filter would soon be gone. And here's the reason that she gave. This feature is barely used by Snapchatters. And in light of that, we are removing it altogether. So we want to know, it's barely being used. What does that mean? Here are some of the speed filter metrics that we do know. We know that in September 2015, the month that this crash occurred, there were 32,561,000 speed filter snaps taken that month. We know that 804,992 individual separate users used the speed filter that month. We know that about 7 months later, 9 months later or so, there were 58.7 million speed filter snaps taken in the month of July 2016. So what does it mean it was barely being used? How do we test the veracity of that statement? Well, we noticed 30B6 topic 33B, which is Snap's written responses to interrogatory number 16. And here's what ROG 16 says. It says, identify the person who made and or released the statements to the media, to the NPR, and include in your response whether Evan Spiegel's approval was obtained. Snap responded identifying Rachel Rakuzin, Senior Director of Communications. So they designated Mr. Cheek to talk about this statement, and we asked Mr. Cheek, so you spoke to Rachel Rakuzin before this deposition, and she was identified in response to interrogatory number 16, right? And the answer was yes. But somehow Mr. Cheek said he had not spoken to her about this, the very statement that we were there to talk about. We asked, have you ever spoken to her about that statement? No, I don't believe so. Well, have you spoken to anyone at Snap about that statement? No. So as a result, of course, he's unable to testify about the underlying data for that statement or the basis for that statement. Do you know how many people were using the speed filter? I don't. Do you have an understanding of the context and accuracy of her statement? Yeah, we had an objection that this was not one of his topics, but as we showed you, it actually was. And the witness said, I don't have any personal knowledge on that topic. And so remember, he says, I have not spoken to the witness or anyone at Snap about this topic. But 5 hours into his deposition, there's a break. His counsel called for a break, and Mike said, what, we just took a break about an hour ago, and the witness said, actually, I need to use the bathroom. So the break ensued and lasted, I think it was 19 minutes. And this is what we received when we came back. It should.
And we're back on the record at 3:17.
So, did you talk to your lawyers during the break about this case?
I did.
Okay. So we looked at documents that showed that Snap would.
Excuse me, just before we get started, I wanted to make a couple corrections for the record.
Are these corrections that you're making after discussing them with your lawyers?
They're, yes.
Mm-hmm. What do you want to say?
So, in regards to the statement made by Rachel Rakuzin to NPR, in my conversation with her, we did discuss the statement, and I asked her if she had made it, and she said that she had, and that Evan was not involved in approving the statement or creating the statement.
Okay, so that's a complete reversal of his prior testimony that morning. But that's not all. It turned out he forgot he had spoken to someone else.
I also spoke to Evan about his knowledge of cases where it was alleged that the speed filter was being used in connection to car accidents.
Okay. So, wow, now he has spoken to Evan Spiegel, and, you know, he works at Snap. Maybe he spoke to Mr. Spiegel a while ago. Maybe that's why he forgot.
This is remarkable. When did you have this conversation?
I spoke to Evan yesterday.
Okay. And it's 3:20. The deposition's been going for 5.5 hours almost, right? And now you just remember that you spoke to Evan Spiegel?
Well, I spoke to Evan Spiegel.
Yesterday.
Well, I wasn't that I just remembered that I spoke to Evan Spiegel. As you can tell, there wasn't a lot that came from that conversation that I didn't think was relevant in the course of the question so far. But I'd like to make sure that I correct the record now.
So you produced an exhibit, and Evan Spiegel's not on the exhibit, right? It's a yes or no question.
He's not on that, no.
Okay. Which lawyer reminded you that you spoke to Evan Spiegel?
Well, I didn't need a reminder that I spoke to Evan Spiegel.
So how did it come up after 5.5 hours and the production of hundreds of pages of paper and 4 names that his name, how did it come up after that
Look,
time?
there's a lot going on right now. I'm trying to think of a lot of different documents and a lot of different conversations.
Okay. So, we still need to understand why Snap removed the speed filter. So the next day, we asked 30B6 designee Ms. Morka Yanis. Snap had designated her to testify about topic 17, which is the origin, creation, approval, marketing, distribution, and elimination of the speed filter. And again, Snap has publicly given a reason for removing it. But this is the response we received from Ms. Morka Yanis.
What was Snap's rationale for eliminating the speed filter?
Objection calls for privileged information. Instruct the witness not to answer unless you're able to provide information that's not based on privileged communications.
I'm not able to answer.
Okay, you're going to follow the advice of your attorney not to respond to that question?
I'm not able to answer.
Are you not answering because you're relying on the advice from your attorney? Or you're not answering because you don't know?
I don't know.
You don't know why Snap eliminated the speed filter?
I don't know.
Okay. You are identified for topic 17, the origin, creation, approval, marketing, distribution, and elimination of the speed filter to include the speed sticker, right?
Yes.
Okay. But your testimony today is that you don't know why they eliminated the speed filter, correct?
Correct.
Okay. Why are you not prepared to address that question?
I disagree that I'm not prepared to address the question.
Okay, but you don't know the answer.
I don't know the answer.
Okay. Snap knows why it eliminated the speed filter, doesn't it?
It's privileged information.
Okay. So you're not answering because it's privileged information and you're following advice of your counsel? Or you're not answering because you don't know the answer to the question?
I'm not answering because I don't know the answer to the question because the information is privileged.
And so, and again, I can't overstate this. Snap has already publicly stated reasons why it removed the speed filter. And now it's refusing to answer on the basis of privilege. So as we stand here, we still don't have an answer to why Snap removed the speed filter. We don't have an answer as to what was the basis for Snap's spokeswoman telling NPR, telling the public that this is why it removed the speed filter. So this is a segue now into our next topic, which is instructions not to answer. And you heard some of that in the last clip. Another thing we wanted to understand, what are Snap's contentions in this case and what are the factual bases for these contentions? And so we served interrogatory topic number 31, which is SNAP's investigation, knowledge, and contentions regarding the September 10, 2015 crash. And these are the types of questions we asked during the deposition. Who did SNAP's investigation? What did SNAP do to investigate? When did SNAP investigate the wreck? How long did SNAP investigate the wreck? What contentions does SNAP have concerning the wreck? Does SNAP believe that Krista McGee was using the app that night? How fast does SNAP believe Krista McGee was driving? What knowledge does SNAP have about the wreck? And these are similar to SNAP's own discovery requests that they submitted to the Maynards. They asked, please describe in full detail how the accident happened, including in your description, the exact location, et cetera, et cetera. State with particularity the factual basis upon which you allege SNAP Inc. was negligent. State with particularity all factual bases for the allegations in your second amended complaint. State with particularity all facts indicating that any driver or passenger involved in the accident was using Snapchat. State with particularity all facts related to how Snap Inc., Snapchat, or the speed filter caused the accident. These are discovery requests they served to us, to our client, who is brain injured, who can't remember anything about the wreck, and any knowledge that the plaintiffs collectively would have would be through the work of their attorneys. But we respond to these requests. Not Snap, though. When we asked Snap about the investigation, the witness said, I'm not aware of the details of the investigation. And you'll see a couple of those, I'm not aware, I don't know. We didn't put the whole transcript in here, but many times these were prefaced by instructions not to answer unless you have personal knowledge. So I don't know who did the investigation. I don't know what was done to investigate, and there's one of the objections. And you can't tell us when Snap conducted an investigation into the wreck? No. Can you tell us how long Snap investigated the wreck? I cannot. As we sit here today, you're not able to provide any contentions that Snap has with regard to the wreck, are you? I'm not. Was McGee using the app that night? And again, objection carried on to the direction of attorneys and therefore covered by work product privilege. And so the witness declined to answer. How fast does Snap contend Krista McGee was driving? Same objection, same instruction. The answer to that question is attorney-client privileged. Refused to answer what it contends happened. But does that mean Snap accepts what the plaintiff's description of the wreck is? No, it doesn't mean that. You can't answer the question. So we dispute the plaintiff's account of the wreck, but we're not answering these questions because they're work product and attorney-client privileged. And I think this really sums up Snap's position, and this is what we experienced during the deposition. What knowledge does Snap have about the wreck? And the objection is, I'll object that whatever knowledge Snap has is a product of attorney investigation and is covered by work product. But that is not correct. In Georgia, a party's contentions, opinions, and conclusions are proper topics for discovery. The Georgia Supreme Court has held that a party's contentions, opinions, and conclusions are discoverable. And I'm citing G.H. Bass and Company versus Fulton County Board of Tax Assessors, 268 Georgia 327. And in that case, it said the 1970 amendment to Federal Rule 36, and this is on RFA specifically, was intended to liberalize the practice with regard to discovery of opinions, conclusions, and contentions. It made explicit the rule that discovery could be had of opinions related to fact or the application of law to fact. This change makes it possible to discover the contentions of parties. The Georgia Court of Appeals has similarly held that a party's contentions, opinions, and conclusions are discoverable. It says, The depositions are always available to discover any evidentiary basis for a party's defenses. And we've cited Exum v. Melton, 244, Georgia Act 775, as well as Carver v. Tift County Hospital Authority, 268, Georgia Act 153. The Georgia legislature, in addition, has codified that opinions and contentions are discoverable. And it says that an interrogatory otherwise proper is not necessarily objectionable merely because an answer to the interrogatory involves an opinion or contention. It also authorizes discovery in OCGA 9-1126B1 related to the claim or defense of any other party. The Northern District of Georgia has held that the same are discoverable. The designated witness, the 30B6 witness, must testify not only to the facts within the corporation's collective knowledge, but also about the corporation's position, beliefs, and opinions. Work product is one of the two objections, the two protections asserted by counsel during the deposition. But work product does not protect facts. We're citing here a treatise, Georgia Law of Torts, section 25.1, which has other citations below it. But the work product doctrine does not protect underlying facts or materials developed in the ordinary course of business of a party. The underlying facts discovered in preparing work product documents and the identity of parties from whom the facts were obtained. Garcia v. City of El Centro says, because the work product doctrine is intended only to guard against divulging of attorneys' strategies and legal impressions, it does not protect facts concerning the creation of work product or facts contained within the work product. And finally, I think this one is crucial here. Litigants cannot escape their obligations to disclose underlying facts by communicating them to an attorney or having an attorney direct the fact investigation. That's from In Re Dominion Dental Services, USA, Inc., 429 F sub 3rd. Now,
that's the first time you've lost me. Give me just a second. I've been pulling the cases and tagging them as you've referenced them.
Yes.
But I didn't get the last one. Give me just a second. It pulled up something different. 429 F sub
3rd, 190 at 193.
And I know these are in your brief, but as y'all are bringing my attention to them, I'm tagging them as both in the brief and referenced here.
Understood.
There it is. I have it now. Sorry to interrupt.
Not at all, please. And I hope you and Mr. Hope would interrupt with questions as they occur to you. In addition, so we talked about work product privilege. Attorney-client privilege does not protect facts. This is the U.S. Supreme Court in Upjohn v. United States, 449 U.S. 383. And this is at 395 to 396. The protection of the privilege extends only to communications and not to facts. A fact is one thing, and a communication concerning that fact is a different thing. The client cannot be compelled to answer the question, what did you say or write to your attorney, but may not refuse to disclose any relevant fact within his knowledge merely because he incorporated a statement of such fact into a communication with his attorney. The Georgia Supreme Court is on the same page, 282 Georgia 631 at page 636. And it reminds us that the statutes outlining attorney-client privilege are not broadly construed, but rather they're construed to the narrowest permissible limits. And the reason for that is excluding facts pursuant to attorney-client privilege results in the exclusion of evidence, which contravenes the view that the ascertainment of as many facts as possible leads to the truth. And the discovery of the truth is the object of all legal investigation. So instead of citing to the U.S. Supreme Court or the Georgia Supreme Court or the Georgia Court of Appeals, SNAP misrepresents Georgia law and cites to a state court case in which Judge Morrison, they say, granted a protective order to Grady Hospital. SNAP's brief on the case is Garcia Diaz v. Morehouse, 2021 Georgia State Lexus 2873. This was in 21. SNAP's brief claims that Judge Morrison, and I'm quoting from their brief, ruled a corporate defendant was not required to testify regarding evidence the defendant intended to rely on in defense of the case. I think page 13 to 15 of their brief goes through this at length. There's a block citation, and the judge said this, and the judge said that, and the judge said the other. But in fact, Judge Morrison denied that motion for a protective order. What SNAP was citing to you is the arguments made by Grady's counsel in their bid to block or limit the 30B6 deposition topics. And this is actually the disposition of that motion, denied. I've brought copies if I may approach them.
And y'all may move about freely.
Thank you. That's what you have before you. One word, denied, was Judge Morrison's assessment of the defendant's arguments. So I want that to be very clear that none of that was coming from an order, albeit a state court order in Fulton County. So we think it is very clear we should have been able to ask and receive answers to the types of questions we posed to the witnesses, and we were barred from doing so. The next issue we want to address is speaking objections. Hall v. Clifton Precision, which we talked about earlier, says that objections must not cue the witness. A deposition is meant to be a question and answer conversation between the deposing lawyer and the witness. There's no proper need for the witness's own lawyer to act as an intermediary, interpreting questions, deciding which questions the witness should answer, and helping the witness formulate answers. It is the witness, not the lawyer, who is the witness. Another case, and I do acknowledge this is a district court case, and so it's not binding precedent on this court, but I think the language is very on point. Instructions to a witness that they may answer a question, quote, if they know, or if they understand the question, are raw, unmitigated coaching and are never appropriate. This conduct, if it persists after the opposing attorney requests that it stop, is misconduct and is sanctionable. This is from Cincinnati Insurance Company v. Serrano, U.S. District Court, Lexus 1363 at page 12. But this is in line with what Georgia judges have codified in their standing orders. Again, referring to the same standing orders we provided, counsel shall not make objections or statements that might suggest an answer to a witness. Counsel's statements when making objections should be succinct and verbally economical, stating the basis of the objection and nothing more. This is a sample of some of the objections we received. You can answer if you're able. Again, you can answer if you're able. Beyond SNAP's knowledge and vague. You can answer to the extent you're able. Vague as to what idea. Vague and calls for a legal conclusion also. Vague calls for speculation. In one case, counsel answered the question for the witness. I'm going to object. Snapchat continues to investigate this. And I'm interjecting myself, and this is after Neff said, you're testifying. Counsel said, I'm interjecting myself because you're well aware that Snapchat continues to investigate. It hasn't received full discovery. In another case, Mike said, your understanding of the answer to that question is privilege, right? And counsel, what question? Mike said, the question I just asked. And of course, and this happens several times as we point out in our brief, but the witness picks up and echoes the objection. Again, you can answer if you're able, assumes facts not in evidence. Questions about contentions are inappropriate for a lay witness. Do you have any knowledge? And so it was our feeling that these types of objections, and many times the witness picked right up on it, obstructed our ability to fully cross-examine the witness and understand what we came to understand. And I think this is the last issue we have on this point. And this is unprepared witnesses. Now, you will hear, I'm sure, when I sit down, you will hear, we spent this many hours and spoke to this many people, and we did all these things, and yet this plaintiff still is complaining. But I'm going back to another of our hearings. The court said, I don't care who you designate, so long as they're prepared. This came up because you may recall when the court said, plaintiff chooses, SNAP said, well, we're going to withdraw our witness and pick someone else. And the court said, I don't care who you pick, so long as they're prepared. And so what SNAP did is chose people who were not employed anywhere near the time of the events that give rise to this incident. Now, let me back up though. As we all know, preparing a 30B6 designee, and this comes from QBE Insurance Corporation v. Jordan Enterprises, Inc., 277 FRD 676. Preparing a 30B6 designee may be an onerous and burdensome task, but this consequence is merely an obligation that flows from the privilege of using the corporate form to do business. The fact that time has passed or an organization no longer employs a person with knowledge on the designated topics does not relieve the organization of the duty to prepare a Rule 30B6 designee. That's from Great American Insurance Company of New York v. Vegas Construction Company, 251 FRD 534. Now, having said that, we recognize it is not a pop quiz, it's not a gotcha opportunity. At some point during the deposition, the witness will say, I don't know. The witness cannot possibly know every question that two motivated lawyers can think of. And so we have been careful to bring to the court only those issues that we think are substantive and should have been, the witness should have been prepared to answer. Now, here's what I was saying a few moments ago. SNAP chose two witnesses who were hired long after the events at bar. In December of 2013, SNAP introduced the speed filter. In November of 2015, the McGee wreck occurred. In November of 2016, SNAP introduced a blackout. Ms. Morkayanis was not hired at SNAP until January of 2018, and Mr. Cheek was not hired at SNAP until October of 2018. That's 5 years after the crash itself and years after some of the other milestones that we think are important in this matter. So you will hear about who he spoke. Yes,
I'm
Judge.
sorry, the blackout, I don't remember. I
Yes.
lost that.
There was a point where SNAP blacked out speeds between 50 and 150 miles per
Okay,
hour.
that's what I missed.
Yes,
I had a moment where I was like, nope, I didn't get that.
that's it.
Okay.
That's it. So that was in November of 2016. Now, so Mr. Cheek and Ms. Morkayanis, they were hired later, and I can't tell SNAP you need to identify someone who was employed at the time. They can identify whoever they want. But if you pick someone, and that's where we use the term a blank slate, not because the witness knows nothing, but the witness knows nothing about the relevant issues other than what someone tells them or they find out. In this case, a lot of their prep was by lawyers, and a lot of their prep was from, in Mr. Cheek's case, 4 witnesses, possibly 5 if we accept Evan Spiegel. But other than Evan Spiegel, one question the court might have for SNAP is, were any of these people you spoke to around when the speed filter was introduced at the time of the McGee wreck? So, however it fell, however much time they claimed to have spent preparing, he was unable to say who was responsible for safety in 2013. And I'll pause there because in SNAP's response, they act like this is, I think I said we won't be asking who was the 3rd assistant regional manager in Borneo. And they compared this question to that. But 2013 is when the speed filter was released. And during Ms. Morkayanis' testimony, she talked about, I don't know, but I'm sure they observed safety protocols, and I'm sure there were safety discussions because that's usually what we do. But at the time this was released, there were 35 employees. So asking who was responsible for safety in 2013 is not a random gotcha question in our view. We asked the demographics of speed filter users. That's from topic 11. He was unable to testify about that. He was unable to testify why Snap does not track the age of users. See topic 11. Whether Snap tracks demographics of people using other filters. Topic 11. He was unable to testify anything about prior cases, such as the Amoni Barton case. And here's a civil docket sheet showing that actually Ms. Barton filed suit. And this was produced to us by Snapchat. So they knew about this, but Mr. Cheek was unable to testify, didn't know anything about it. He was unable to testify about the Pablo Cortez case. And the Pablo Cortez case was a horrible crash in Tampa, Florida, where this gentleman and his girlfriend were driving and they posted 115 miles per hour using the speed filter, and shortly thereafter crashed into a minivan, 5 people killed. And Snap gets Google alerts. And here's one from November 2, 2016, which I think is a few days after the crash. And within that Google alert, here's the story. Snapchat video shows car hitting 115 miles per hour moments before horror crash which killed 5 people. And you can see that Bates number at the bottom right of the underlying document. Snap produced this document to us. But the witness was unable to testify about it, didn't know anything about the Pablo Cortez case at all. And that was in Tampa, I told you. And here is a meeting from one of Snap's engineers. He's called a Google meeting, and it says sync on Tampa speed filter. Again, this is something that Snap produced to us, and Mr. Cheek was unable to testify about it, didn't know anything about it. Ms. Morkayanis was also unable to testify about issues like who came up with the speed filter? Was there a document used to propose the speed filter? Were there meetings about the speed filter before it was released? What, if any, safety by design principles Snap used in 2013? And that quote, the safety by design is, I think that's a term she used. Whether a product specification form, again, you said quotes, that's another of the terms she used. Whether a product specification form was existed when Snap developed and released the speed filter, whether Snap was aware of the risk posed by the speed filter and how it responded to that risk, who at Snap first expressed concern about the speed filter and its safety, the meaning of Mr. Lin's email or Mr. Wang's response, and here's that email. This is from a Fidelity fund manager who helped Snap manage its money, and he said, have y'all ever reconsidered the speed filter for obvious reasons?
Actually, Fidelity also had a direct investment in Snap.
Oh yeah, excuse me, Fidelity had a direct investment in Snap, so yeah, they had something at stake there. Have y'all ever reconsidered the speed filter for obvious reasons? And the response from Mr. Wang was, yo, feel free to give me a ring anytime, smiley face. And it's not a random email. Of course, Snap produced this to us, but other documents produced by Snap showed that Mr. Wang forwarded this to Snap's legal counsel, and there was discussion on it. Unfortunately, it's all redacted, but we think this is not a random nitpicky question. This is a substantive issue. What was Snap's response? She was unable to talk about the meaning of the email or the response. She was unable to say who suggested that a don't snap and drive warning was sufficient to offset the danger posed by the speed filter. Why Snap eventually removed the speed filter, as we played you that clip. Who came up with the idea to black out the speed filter at certain speeds, and why Snap did it. And she was unable to testify anything at all about Mr. Maynard's damages. And one would say, I'm sure Snap will say, well, she's not a doctor, and he hadn't deposed him yet, but we had given Snap records years ago, and they've had records and records and records, and Snap designated her to testify about this, and she just had no position on it. And maybe there won't be a dispute on it, but we don't know. So as I wrap up this argument, I'll leave you with a case not cited by SNAP at page 4 of their brief, Manufacturers Alliance Insurance Company v. Brencorp, Inc. SNAP cited that, if I recall, for the premise that one of the things the court looks at is how much time and effort was spent preparing a witness. But what else? Here's what else the case says. It says if a party has objections or disputes to topics in the 30B6 notice, the proper course of action is to file a pre-deposition motion. The party that receives the Rule 30B6 notice cannot simply refuse to obey it. And I expect part of what you'll hear after I sit down is these topics were broad, these topics were vague, we don't like these topics, we didn't know what this meant and that. But there's not been a motion, there's not been a protective order, and so we go forward into the deposition and run into problems, and that's not how it's supposed to happen. And this is the case, again, that SNAP cited. Rule 30B6 obligates the responding corporation to provide a witness who can answer questions regarding the subject matter listed in the notice. If the designated deponent cannot answer the questions, then the corporation has failed to comply with this Rule 30B6 obligations and may be subject to sanctions. We think that's what happened here. We put the evidence in front of the court and see, court, do you agree that these were appropriate questions, appropriate topics, and that the objections, the witness conduct, the lack of memory, the lack of knowledge, the changed testimony during breaks, was that inappropriate? And was that as shocking as we think it was? And unless the court has questions, I'll sit down and give SNAP the floor.
No, and I'm good, thank you.
Thank you.
Mr. Messon, the floor is yours. You may sit or stand as you prefer. And if anybody ever needs a break, just let me know. So I think Mr. Khan, we might need to reset this. I'm having trouble pulling Mr. Khan back up.
Oh, I can.
No, it's on my end.
Your Honor, can you hear me? See me now?
I can hear you great. The CU is on my end. Give me just a second. Again, this system is version 1.0 and it's about to be upgraded. And it did this in a trial a couple weeks ago. Let's do this. Let's just take a quick break for everybody. Mr. Khan, I'm going to